Do you understand and appreciate that a voluntarily and knowingly made plea of true to one or more violations of probation? That's enough to grant a motion to revoke probation. Your probation can now be revoked. You can be found guilty and sentenced to the full range of punishment. This is a second-degree felony. You are exposing yourself to no less than 2 nor more than 20 years confinement in prison.
This starts as routine, but don't get comfortable. A man already on probation for a deadly weapon assault is back in court, not for a mistake, but for a new crime, evading arrest. And instead of fighting it, he's about to admit everything. The judge lays it out clearly. You say, true, you risk years behind bars. And what does he do? He agrees. No hesitation, no pushback. Just, yes, sir. This isn't confusion. This is a calculated gamble. And now the judge is in control.
Cause number 20-34716 is first call, the state of Texas versus Ashton Vondre Spearman. That's you, sir? That's a elegant name, I'll tell you. And you were here with Mr. Cole and Ms. Minaldi, your attorneys, and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation, which I believe is the most recently filed motion in this case? And can we proceed in summary? Mr. Spearman, please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this first amended motion to revoke unadjudicated probation, which was filed on November 7th of 2025, states that on December 13th, 2021, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for a period of 10 years for the second-degree felony of aggravated assault with a deadly weapon. Is all of that true and correct, sir?
Yes, sir.
All right. Let's take up he's going to be pleading to which one?
1640.
Okay, is this alleged? Looks like it is. Is this alleged as allegation 10 in the first amended motion? This 25 CR 1640,
Yes,
for
sir.
which the defendant will be pleading to subsequently.
Yes, sir. That's the evading arrest.
All right.
We can scratch
Yes.
out on that
We'll
number
just-
10. We'll take out the tampering with identification number. That's when we're dismissing. So we can move to amend that.
Any objection?
Objection, sir.
Tampering with the identification numbers. It says committed the offense of evading arrest and unlawfully carrying a weapon. What about that?
We'll take that off, Judge. That's been,
That too?
yes, sir.
We didn't. All right, allegation number 10 as edited and deleted states that the said Ashton Vondre Spearman committed the offense of evading arrest on or about September 20th, 2025 in Jefferson County, Texas, which is a violation of condition 1 of your deferred or unadjudicated probation order, which states do not commit another offense. Is that allegation true?
Yes, sir.
Are you pleading true voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand and appreciate that a voluntarily and knowingly made plea of true to one or more violations of probation? That's enough to grant a motion to revoke probation. Your probation can now be revoked. You can be found guilty and sentenced to the full range of punishment. This is a second-degree felony. You are exposing yourself to no less than 2 nor more than 20 years confinement in prison. You understand?
Sure.
Knowing that, do you insist on pleading true today? I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true to allegation number 10 of this first amended motion to revoke probation. An agreement has been reached here. That your probation would, first of all, your probation would be revoked. You would be found guilty and sentenced to 5 years in prison. This will run concurrently with the case 1640 that we're going to be going into next, the substantive new indictment of evading arrest or detention with a motor vehicle. Is that your understanding of the plan?
Yes, sir.
If I follow this, and by the way, another case, 1641, that's 25 CR 1641, will be dismissed. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
We'll show you what's marked as States Exhibit 1. Did you sign that document in this case, this motion to revoke probation? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence
Yes.
without objection admitted. Among other things, this states you were giving up all rights of appeal if I follow this agreement, which I intend to do. States Exhibit 1, part of the record for all purposes. Anything else to add on this first amended motion to revoke unadjudicated probation by any party? If not, I'm going to find that, Mr. Spearman, you have entered your plea of true to allegation 10 of this first amended motion to revoke unadjudicated probation in this cause number 20-34716. You have done this intentionally, knowingly, intelligently. And that is enough to grant this motion by preponderance of the evidence or greater. Thus, your deferred or unadjudicated probation is hereby revoked as I find that allegation of a violation of probation number 10 by committing the new offense of evading arrest is proven beyond a reasonable doubt. Thus, your probation is revoked. Earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted at that hearing that we placed you on deferred or unadjudicated probation for on December 13th, 2021. There was enough evidence there presented to find you guilty beyond a reasonable doubt. Now I hereby find you guilty based upon the revocation of that deferred probation order. You are hereby found guilty beyond a reasonable doubt of that second degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And I don't have a choice on this, but the judgment shall reflect that an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this assault. Do you understand what has happened today, sir?
Yes, sir.
That affirmative finding will affect your parole time. You won't be eligible for parole until you serve 50% of your time, but that's the law. Firearms or other is a deadly weapon used in the commission of an offense supports an affirmative finding by law. And that is the ruling of the court in this case. Next, we go to 25 CR 1640. And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
Your voice is getting higher as the hearing proceeds.
This is the dream team.
Okay, in summary, sir, this indictment alleges that on or about September 20th, 2025 in Jefferson County, Texas, you committed the third degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in this case where you would be pleading guilty, sentenced to 5 years in prison, which would run concurrently with the preceding motion to revoke probation that the court ruled upon and granted and sentenced you to 5 years on previously. And also, as part of this, 25 CR 1641 is a pending case that will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence and
Objection.
without objection admitted. As the case before, this Exhibit 1, State's Exhibit 1 states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know intimately what you're charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyers. All of this is true right here. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I will follow this agreement if nothing further. How do you plead to this? Guilty or not guilty?
Yes.
And you're pleading guilty voluntarily and because you are guilty of this.
Yes, sir.
All right. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. Because there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here, finds you guilty beyond a reasonable doubt. I'm going to follow this agreement, and I hereby find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. The sentence shall run concurrently with the previous case that was dealt with in the motion to revoke probation. Do you understand what has happened here, sir?
Yes, sir.
Stand by. You're going to follow up with a motion to revoke? Motion to dismiss?
Should be
Okay.
one somewhere queue, Judge.
Sorry, Judge. It's.
I've got something on a Bryce Smith, but that's the only.
Yes, sir. That's an MTRP hearing that I'm dismissing the MTRP. We've got an amendment. We need you to sign on that. And then
Mr. Spearman, this 25 CR 1641 is before me. There's a motion to dismiss. Without objection, I'm going to dismiss this. That case is hereby dismissed. Anything else to add? Thank you very much. Good luck. Bye.
2 cases, 2 guilty pleas, 1 outcome, prison. The judge didn't overreach. He followed the law and the defendant's own admissions. This wasn't taken from him. He handed it over piece by piece. So here's the real question. Was this accountability or just someone giving up? Do you think the judge was right, or did the defendant throw away his last chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.